Right out of the gate, we're in what's called a charge conference. This is where both sides fine-tune the instructions the jury will use to decide the case. And here's the thing. A single word change in these instructions can literally impact someone's fate. So ask yourself, how much power should wording really have in a criminal trial?
Third state's attorneys present, defendant and defense counsel are present. We have met informally with regard to some changes in the court's proposed charge. I've given you each a copy of the charge with those agreed upon changes. Are there any other requested additions or corrections or objections? I'll give you both just a second to make sure.
This is a classic courtroom frustration moment. The attorneys know the wording is confusing, but they're stuck with it because the law requires it. That's the reality of legal procedure. Sometimes clarity takes a back seat to statutory rules. Ever wonder how many jurors get tripped up by language like this?
I just found something. On page 4 under parole, it has that example which says if he's, and it's really just an example, but it says if he's sentenced to 4, then he has to do 2. It just is confusing because he can't be sentenced.
And I hate that, but it's actually part of the quotated language that the statute says shall be included.
It is. Okay, I'll just leave.
I don't think we can
Yeah.
submit it.
Okay.
I guess we
It's
could
just
without
that-
objection, but
Well, I don't think, I mean, it's not saying he's going to get that. It's just explaining to them how to do math. So, okay, never mind then.
Now this might sound minor, but it's actually huge. Twice before versus at least once before could influence how the jury perceives the defendant's criminal history. One sounds definitive, the other leaves room. So the question is, are they aiming for precision or perception?
All right, so anything else with regard to the charge? Mr. Smith?
no, Judge.
Mr. Vasquez?
Judge, is there, well, never mind, just found it. Sorry.
You're good. It's all good then?
Can I have one more minute here?
Yes, sir. On page 3.
Yeah, page 3.
Where it says the state has accused the defendant of having been convicted of a felony twice before, should I say of a felony at least?
What you're watching here is legal strategy in real time. Consistency versus clarity. The judge ultimately leans toward uniform language, but here's the twist. Juries often read between the lines. So does repeating at least subtly reinforce prior guilt? What do you think?
Once before or something like that?
I would take the twice out. I would say at least. No.
What do you think it should say?
Here's the defendant of having been convicted of.
At least once before. That's the language that we keep using, is at least once before,
Right.
right?
Yeah, a felony. Just wait that sounds. I mean, of having been previously convicted of a felony, of at least one felony. Does that sound all right? It's not what we've been saying, though.
No.
Just for consistency, I guess.
I mean, it's a, they both mean the same thing. I'm gonna use the at least just because we keep you, so it reads, the way I have it, the state has accused the defendant of having been convicted of a felony at least once before. That's what it says everywhere else.
Can you lose the at least, Your Honor?
But we've been putting at least everywhere else because it only requires one. And so I think that keeps it consistent with the other ones. Unless y'all both agree to take that out, but I think we've,
Just keeps it consistent all the way through the charge if you do it that way.
okay. All right, so there's that. What else?
I'm sure we'll see one about 3/4.
As soon as I'm reading it, I know. So I need to print page 3. Stapler, taker, I need to get one of these for my drawer here. Here should be page 3. Okay, with that modification now, are there any requested additions, corrections, or objections?
Not mistaken.
Not from the defense, right?
All right. Anything else?
And there it is, the moment everything shifts. The guilty verdict is already in. This phase is no longer about if he did it. It's about what happens next. Welcome to the punishment phase where the stakes are just as high, if not higher.
Before we bring the jury in then?
Not mistaken.
Mr. Vasquez, anything else?
No, Your Honor.
All right, you can bring the jury in. Good morning.
Good morning.
Let the record reflect that the jury is seated. State.
This is powerful and devastating. The defendant is admitting prior convictions in open court. That directly impacts sentencing because repeat offenses can significantly increase penalties. So here's the bigger question. Should past crimes weigh this heavily when deciding someone's future?
Attorneys present, defendant, and defense counsel are present. And so let's get caught up on where we are from yesterday. The jury reached a verdict of guilty in cause number 23 DCCR 0329. At this time, I accept your verdict. Find you, Mr. Westbrook's, guilty of the offense of murder. Mr. Smith, you may read the remainder of the indictment. Mr. Westbrooks, if you'll please rise.
And the grand jurors aforesaid, upon their oaths aforesaid, do further present in and to said court at said term, that before the commission of the primary offense, the defendant was finally convicted of the felony of burglary of a habitation, second degree, on April 9, 2012, in cause number 10-08944 in the Criminal District Court of Jefferson County, Texas.
And Mr. Westbrooks, is that true or not true?
True. And the grand jurors aforesaid, upon their oaths aforesaid, do further present in and to said court at said term, that before the commission of the primary offense, the defendant was finally convicted of the felony of robbery, second degree, and on April 29, 2013, in cause number 12-14152 in the Criminal District Court of Jefferson County, Texas.
And is that prior conviction true or not true?
True.
All right, thank you, sir. You can have a seat. All right, Mr. Smith, do you wish to make an opening statement?
Just briefly, Judge.
Go ahead.
Ladies and gentlemen, I want to thank you again for your time, for your verdict. I assure you it was a proper verdict under the law and the facts and the evidence that was given to you in this case. We talked about the separate stages in a criminal trial when we were in Rhode Island. And I told you in the first phase, it's not the time for sympathy, emotion, or compassion. It is simply to determine if the facts amount to a crime. If so, then guilty. If not, then not guilty. Guilt is over. Now we're into the punishment phase. This is where you as jurors help me help all prosecutors out, because this is the benchmark part. This is the part where we know what a jury says should happen to a person with this kind of criminal history, commits this kind of crime in our community, what should happen. So that becomes the job now. And for that, you can take in the totality of the circumstances. You can take in sympathy, emotion, or lack thereof, good things that he's done, bad things that he's done, all of that big picture. And he can be punished based on all of that, not just on that short window of his conduct at that time. Okay? So I just want to let you know that, and thank you again for your verdict. We're going to give you some more evidence, and then we'll get you back to deliberating on the function in this case. Thank you.
Thank you, Mr. Smith. Mr. Vasquez, do you wish to make an opening statement?
Very briefly, Your Honor. I join Mr. Smith in thanking you for your service. Respect your verdict, and be back to talk to you again during closing argument.
All right, thank you, Mr. Vasquez. Mr. Smith, you may call your first witness.
We call Troy Robinson.
Good morning, sir.
Morning.
Do you swear affirm the testimony you're going to give in this trial will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. You can have a seat. You may proceed.
Good morning. Would you state your name and spell it for the court, please?
Troy, T-O-R-O-Y, R-O-B-I-N-S-O-N.
And what is your occupation?
I'm an investigator for the Jefferson County District Attorney's Office.
How long have you been so employed?
A little bit over 7 years with the District Attorney.
Are you a certified peace officer in the state of Texas?
Yes, I am. I hold a master's certification.
And what are your duties as an investigator for the district attorney's office?
So our duties are to assist the attorneys in preparation for trial, look over some of the case files, obtain statements, evidence, locate witnesses, serve subpoenas, testify in court, and particularly for my case, I do some fingerprint comparison work.
Okay. And prior to being at the district attorney's office, where were you employed?
I was at Port Arthur PD for 20 years. I retired from there and then moved over to here at the DA's office.
So are you a fingerprint expert?
Yes, I have been certified as one in this court.
What training and background do you have that qualifies you as an expert in the area of fingerprint identification?
So in 2018, October 2018, I attended a 40-hour core course at Texas Forensic Associates. It's a fingerprint comparison school. Once you complete the course, obtain your certification, you maintain some regular training, and basically we'll call it like testifying in court is part of that. And I've testified in the 252nd District Court on many occasions.
That was going to be my next question. Have you testified before as an expert in district courts here in Jefferson County?
Yes, I have.
Many occasions?
Yes, I have.
What is a fingerprint?
So a fingerprint is a friction on your fingertips or your thumb. You have friction ridges. On the friction ridges are basically oils that your body produces. When you touch something, it's possible to leave a fingerprint, which is considered a latent print. Now latent print is invisible to the eye, so you can't really see it.